Have you ever stopped to think about how a company brands itself when its very product exists in this weird legal gray area?
Yeah,
Like, what if the thing they sell is perfectly legal in one place, but still a federal no-go?
it's a fascinating puzzle.
Well, that's exactly what we're diving into today. We're exploring the, let's say, fascinating and often frustrating world of trademarking vice goods and services.
Right.
And this isn't just about selling something, it's really about navigating this incredibly complex legal maze, where state permissions and federal rules just don't line up.
A kind of commercial limbo, as you said.
Exactly. So our mission for you today is to try and cut through some of that legal jargon.
Yeah, make it clear.
We want to give you a clear sense of why these businesses face such unique branding challenges and what they try to do about it, the strategies involved.
And what's really striking here is that we're looking at industries where branding is just absolutely critical. I mean, differentiating yourself is key.
Yep.
But the legal framework often lags way behind the market realities.
Yeah.
So it raises this big question. How do you build and protect a lasting brand when the ground beneath you is constantly shifting?
It's a huge strategic challenge.
Unlike almost any other, really.
Okay, so let's unpack this a bit. What exactly do we mean when we talk about vice goods and services specifically for trademark law?
Right. It sounds broad,
Hmm.
but legally it's quite specific.
Yeah.
In legal terms, these are basically products and services that, okay, they might be legal in many places, but they're under heavy regulation.
Yeah.
Usually because of perceived risks, public health, morality, safety.
Okay.
They operate in this very specific, sometimes really narrow legal space. And it's those boundaries that create all the complexity we're talking about.
Gotcha. So we're not talking about things that are just flat out illegal everywhere.
No, not at all.
The source material gives examples like, well, alcoholic beverages, pretty common. Tobacco and nicotine products,
Yeah.
including, all the vapes now.
A rapidly evolving area,
Right.
that one.
Definitely. And then cannabis, obviously, in states where it's legal. Gambling, betting services, even adult entertainment.
And firearms,
Yeah.
interestingly, in some jurisdictions due to heavy regulation.
Right, firearms too.
And the really crucial point here, the thing to grasp, is how dramatically these laws can differ from place to place.
State by state.
Exactly, state by state. What's perfectly legal and regulated, say in Nevada, might be totally prohibited next door. Or, critically for trademarks, still banned under federal law.
Ah, okay.
And this patchwork map, this jurisdictional complexity, that's precisely where the brand protection headache really begins for businesses wanting any kind of national reach.
Right, and here's where it gets really interesting, isn't it?
Yeah.
You'd naturally think, okay, a business is operating legally in its state, got all the permits following the rules. It should be able to protect its brand federally. Seems logical. But that's often not the case for these industries, is it?
That's the core dilemma. You've nailed it. Businesses in these sectors, they constantly hit these significant roadblocks with the U.S. Patent and Trademark Office, the USPTO.
Why exactly?
Well, the fundamental issue is that trademark protection, the kind that gives you nationwide rights, is federal.
Okay.
And if the specific good or service is illegal at the federal level, the USPTO generally just refuses registration, full stop.
Wow. So it doesn't matter if you're huge in California or Colorado.
Doesn't matter. If federal law prohibits it, your brand basically hits a wall at the national level when it comes to registration.
Can you give us a concrete example?
Yeah, let's take cannabis. It's
Okay.
probably the most prominent example right now.
Okay.
Even though it's legal medicinally or recreationally in, dozens of states now,
Many, yeah.
it's still classified federally as a Schedule I controlled substance, right alongside heroin, still. So the USPTO consistently refuses to register trademarks for cannabis products themselves. Flour, edibles, things containing THC. And the reason they cite is that federal law requires lawful use in commerce for registration.
Lawful use in commerce.
Exactly. And from the federal perspective, for cannabis, that lawful use simply doesn't exist. State laws don't override that federal definition for UAPTO purposes.
So this isn't just a cannabis problem then?
Oh, no, not at all.
The sources mention similar issues, right? Like for businesses tied to gambling operations that might be legal locally but not federally.
Yes, or even certain tobacco or vape products that haven't received specific federal approvals yet. If it's not federally lawful, getting that trademark is tough.
Which creates this really precarious situation. A brand could be, incredibly successful locally. Everyone in that state knows it.
A household name, potentially.
Right. But they lack that federal shield, which leaves them incredibly vulnerable, doesn't it?
Absolutely vulnerable. to infringers, copycats, competitors, maybe setting up shop with a similar name just across state lines.
A huge risk for any business trying to grow.
Massive risk.
So, given these, pretty major federal roadblocks, how do businesses in these spots even start to protect their brand if direct registration for the main product is, well, a non-starter?
Yeah, non-starter is often the right word.
What do they do? What are the workarounds?
Well, they get creative. It's really a testament to business ingenuity, I suppose.
Okay.
Often they try to navigate these restrictions by seeking trademark protection for things that are associated with the core product, but are themselves perfectly legal federally.
Associated products, like what?
So, for example, a cannabis brand might register its mark for branded apparel, t-shirts, hats, hoodies.
Ah, merchandise.
Exactly. Or maybe for educational services about cannabis use, or even for products made from hemp-derived CBD with no THC, because those can be federally legal now under certain conditions.
Okay, so it's like building the brand identity through these legal adjacent items.
Precisely. It creates a sort of tangential protection for the brand name itself.
And what about, say, an online gambling brand? They might try registering a mark for the software they use.
Yes, possibly the software platform, or maybe framing it as general entertainment services rather than specifically mentioning the gambling activity.
So you're branding the infrastructure around the vice, not the vice itself.
That's a good way to put it. They're looking for legitimate, federally compliant avenues to anchor the brand name legally.
But how successful is that? Does the USPTO just let that slide?
Not necessarily. This strategy has significant limitations. The USPTO examiners are very aware of these tactics.
They know what's going on.
Well, absolutely.
Yeah.
They scrutinize these applications really carefully. They want to make sure it isn't just a backdoor registration for something that's federally illegal.
A backdoor registration.
Yeah. They even have a term for it sometimes, like naked branding. If it seems the legal goods, like the T-shirts, are just a pretext, a fig leaf, to market the illegal core product, and there's no real genuine business in the legal goods themselves.
They can reject it.
They can, and often do, reject it on that basis. So it's definitely not a guaranteed path. It requires a careful legal strategy to show real, lawful use of the mark on those legal goods or services.
Okay, so that's tricky. What about just registering the mark in the state where it is legal? That seems straightforward.
It is straightforward, and it's a very common approach. Businesses absolutely do pursue state-level trademark registrations where their product or service is allowed.
Makes sense.
But if we think about the bigger picture, about brand growth and ambition,
It's limited.
very limited. It significantly curtails your brand's reach. Your legal protection is only as wide as that state's borders.
Right.
So your brand is basically exposed everywhere else. If someone starts using your name in the next state over where you're not registered,
You have less recourse.
much less, potentially none under trademark law. It's like, building a strong fence around a tiny part of your property, but leaving the rest wide open. Effective locally, but not great for expansion.
This whole area just sounds incredibly dynamic. Things are changing, right? The sources suggest laws around some vice goods, especially cannabis and betting, are evolving fast.
They are evolving, yes,
Yeah.
quite rapidly at the state level.
So what does that mean for trademark law, which, let's be honest, often feels like it moves a bit slower?
Laughed slightly,
No.
that's fair. It definitely highlights a crucial tension. Trademark law is slowly adapting, but it's a protracted process.
Yeah.
You have this clash between shifting public opinion, widespread state legalization for some things, and then this very entrenched federal law. It creates this complex, often contradictory environment.
Are we seeing any shifts at the federal trademark level yet?
Some subtle ones. For example, while the USPTO still refuses marks for THC products, they have started allowing trademarks for certain hemp-derived CBD goods, but only if they comply with all FDA regulations and don't make disease treatment claims.
Ah, so small steps. Incremental changes.
Exactly. These little concessions show how the legal framework is trying, slowly, to catch up with the commercial reality on the ground. But it's slow.
So for business owners in these industries, what's the takeaway? What's the advice?
The advice from legal experts across the sources is pretty consistent, actually.
Okay.
First, work closely with experienced legal counsel, someone who really understands this niche area.
Makes sense.
Second, thoroughly assess the risks, understand the federal landscape. Third, actively explore all the available alternative protection strategies, state registrations, related goods, maybe even copyright for logos or design patents for packaging.
A multi-pronged approach.
Definitely.
Yeah.
And finally, prepare for long-term adaptable brand development. This isn't a set-it-and-forget-it situation. The legal landscape is likely to keep changing.
So being proactive and informed is critical.
Absolutely essential for long-term success and just basic brand security in these sectors.
So for you listening, it's about more than just knowing the rules as they stand today. It's really appreciating the incredible complexity here and the ingenious, sometimes maybe audacious ways businesses have to innovate just to protect their identity when the law hasn't quite caught up.
It really underscores how valuable branding is, doesn't it? That companies fight so hard for it, even against these huge legal hurdles.
It really does. Okay, so to wrap up our deep dive today, we've seen that while branding is just as vital in these vice industries as anywhere else,
Maybe even more so.
maybe even more so, yeah, the path to federal protection, that gold standard, is often incredibly difficult, riddled with challenges where state permissions and federal prohibitions clash head-on.
It's a truly unique intersection of commerce, law, and innovation.
Yeah.
And it raises this important question looking forward.
Yeah.
As society's views on what even constitutes a vice continue to shift.
Which they always do.
Right. And as new technologies bring totally novel products and services to market, I mean, think about crypto or AI applications, or maybe even personalized genomics down the line.
Things we can barely imagine now.
Exactly. We are almost certainly going to see more of these kinds of legal gray areas and complexities emerge. The story of trademarking vice goods, it's really a narrative about this constant, intricate dance between entrepreneurial innovation, commercial ambition, and the regulatory landscape that's always twinning, often slowly, to keep pace.
So here's a final thought for you to chew on. Consider how these kinds of legal challenges, this tension between state and federal, between innovation and regulation, might play out in other emerging industries in the future.
Interesting point.
What other goods or services, maybe ones just appearing on the horizon now, could one day find themselves in a similar legal limbo, sparking these same kinds of battles for brand identity and protection? It's definitely something to think about as our world keeps changing so fast.
A fascinating question indeed.
Thank you for joining us on this deep dive. We hope you feel a bit better informed and maybe more curious about this really fascinating corner of trademark law and its surprising frontiers.